Welcome to my channel, All for Health with Jane. Family, the Senzo Meyiwa murder case, it's not as easy as we think. You know, today on the 15th of May 2024, we are in court. Mr. Gideon Rose is on the witness stand, and there is an argument. In fact, my thinking is, if we have law students in the house or those people who are interested in studying law, they could benefit from this argument. What's happening here is Advocate Baloyi, you remember, he led Mr. Gideon Rose in his evidence in chief the other time when Mr. Rose was here. And when he was done, Advocate Baloyi, Advocate Mgomezulu did his cross-examination and he finalized it. It was done. Then after him, Attorney Ramosepili and Advocate Mnisi followed. Ramosepili was done. Mnisi started. And just before Mnisi was about to finish, so that Advocate Nxumalo could start with his cross-examination, they discovered that Mr. Rose had outstanding affidavits and the court had to adjourn. Today, the 15th of May 2024, Mr. Rose is back in court with the information that was outstanding. Now there is an argument, family. There is an argument on where do we start. Whether to start where they ended the last time with Advocate Mnisi doing his cross-examination, or to start with Advocate Nxumalo, or maybe Advocate Baloyi to start leading the new evidence in chief for Mr. Rose. You know, it was just argument. And hence, I'm saying to you, family, that if we have law students in the house, this is the opportunity for them to help solve this puzzle. It is an opportunity for them to learn more about their subject. Family, because Judge Ratha believed that, or maybe according to his understanding, the evidence in chief for the new evidence was supposed to be led first by the state. And then from there, according to him, all the defense, starting from Mr. Mgomezulu, they must start cross-examining Rose into this new evidence, including the old evidence that was presented the other time. But this was different from what the defense believed. The defense, according to them, they said, no ways, we start with Advocate Mnisi where we left the other time. Then that's where we end up hearing Judge Ratha saying, okay, do it your way, and I will do it according to section 167, 167 way, which is the law. He says, I will do it according to the law. So do it your way. So family, let's listen to this argument up to the end.
Okay, so we're recalling Mr. Rose in terms of section what?
Oh, well, he's still under cross-examination.
Yeah, but you remember?
Number 4,
yeah.
Yes, but I'm just thinking, just to do justice to the criminal procedure,
yeah,
how we should go about for him to put the information on record. Our suggestion would be that the additional affidavits are handed up, and that as an expert, he just continues to put the information on record. Then if any of the counsel have got cross-examination starting from accused number 1, Mr. Mgomezulu, then they can do so.
Now, this thing is buried. We had agreed that he'll be recalled and the additional evidence will be led by him and all the annexures, and thereafter he will be cross-examined from the beginning of his evidence. When he says, is it necessary?
That's correct, ma'am.
Yeah, but we've got to justify that in terms of the code.
Yes.
Because once a witness has testified and has been cross-examined. It's different from a witness who testifies and thereafter is cross-examined and it ends there. But when the witness comes and says there's additional information after he has been cross-examined, then the parties should agree. But I think it's section what? 167, Mr. Mugumezo.
Section 167.
Is it so, Mr. Nisi? Section?
167.
Is it 167, Mr. Cholo?
Well,
167 says the court may at any stage.
My Lord, 167
Yeah.
says the court may examine the witness or person in attendance.
Who has been subpoenaed, blah, 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 such proceedings in attendance, da, 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 including an accused. Oh, yeah, well, it says this, including an accused already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if its evidence appears to the court essential to the just decision of the court, of the case. So this covers it, ne? What's your view, Mr. Newman? Quiet.
yeah. We must just keep in mind that the cross-examination is still ongoing.
Yeah, it is, but he's going to testify de novo, in other words, of the new evidence. And thereafter, it joins the old evidence on court. Then, to be fair to the defense starts the cross-examination from the beginning of your evidence, even if you have been cross-examined prior. Okay, so that's how we proceed. Are we agreed, all of us?
As the court pleases. Then previously the court asked the state to lead the evidence, to lead a witness when we dealt with the...
Yeah, remember.
Yes,
With Mr. Dupree.
Yes, when he dealt with Mr. Dupree.
Yeah, fine.
The state was
Yeah,
more than
fair.
happy to lead.
He can't just stand up, Mr. House, even if he's an expert, and start saying, you know, Mandela did this and this. You're going to lead him. Are we agreed?
No, we're not in agreement, my Lord.
So what do you suggest we should do, Mr. Cholo?
My Lord, the state had finished leading evidence in examination in chief. When the questions arose of whatever evidence that was being requested, my Lord, the state had already finished the examination in chief.
That's what I understand it. Did you lead all the evidence in chief?
Well, there is so, my Lord.
And then what happened thereafter?
And the defense started with cross-examination.
Right.
Mr. Mgomezulu conducted his cross-examination
Right.
and finalized it. Then Mr. Ramosepele, Advocate Nesi.
Right.
Then when it got to Advocate Numalo, he then indicated that he needs further information.
Information, right?
So it is at that point
Yeah.
where the proceedings were then adjourned. Hence, I was suggesting that perhaps Colonel Hos can just merely put the information on record.
Which he did not put
Yes,
on record in his evidence in chief.
yes.
Is that not so, Mr. Cholo?
Thank you, my Lord. At least the state has clarified this.
I
that-
clarified it.
Thank you, my Lord. At least the court has clarified, my Lord, that the state had finished
Yes.
its examination in
Right.
chief. Now we're in the middle of cross-examination when the information was requested, my Lord.
Right.
And therefore, after the witness has been able to secure the information that was being requested,
Right.
then the cross-examination has to continue.
No. Then this witness must adduce evidence regarding the evidence which he had to get in hand. Is that not so? Then thereafter you all start your cross-examination from the beginning. Nobody is prejudiced.
No, my Lord, at least I've
No,
placed it
Mr.
on
Cholo, you don't understand.
At least I've placed it on record, my Lord.
Wait. You see there are new affidavits.
Yes, my
3 of them, is that not so?
Yes, two in
Two,
fact.
and they're made by Mr. Holmes.
Yes.
How do we get them on record?
My Lord, the examiner will lead the witness according to those evidence and according to those
Yes,
statements
is
that
that
have
not
been...
evidence then? That's... Baloyi leads this witness on the evidence which is encapsulated in the affidavits, the new affidavits. Is that not how you understand it?
No, my Lord, we've got different understanding. I'll rest my case, my Lord.
Okay, and this is... Yeah, okay.
May I make a submission?
All right.
The court will recall that actually I had not finished my cross-examination.
I know.
Yes.
Yes.
Now, subsequent to the cross-examination of Mr. House being pended, it transpired that there is a new information that the state wanted to put on record.
Right, fine.
As if that is evidence in chief.
Right.
So what I suggest should then happen now is that we should finalize our cross-examination. If there is any further new information that the state would want to put on record through Mr. House, then the state must make that application to recall Mr. House and put that new information into record, and then we all then get afforded the opportunity to cross-examine him on that new evidence. As opposed to the state...
Okay, fine. Now this new evidence, is it going to be recorded in this court?
It is. That will depend on the application that the state is going to make in recalling Mr. House to put that new evidence on record.
Now, according to
because
you,
this is new evidence altogether. It's not a continuation.
Your submission is the cross-examination of this witness should continue from where you ended.
Yes, madam.
Up to Ms. Msholo.
We'll finalize
And
it.
what happens thereafter?
Then the state makes an application to recall Mr. House to introduce
this
new
witness,
evidence.
this is the problem you have. This witness, once you are cross-examining him,
yes,
he may refer to these affidavits. Am I right, House?
That's correct.
I'm long in the game. And how do you have recourse to these affidavits when he refers to them there, when he hasn't led them in chief in terms of 167? Are you with me?
The challenge, my lord, in that regard is, it has never happened that a witness was under cross-examination at the same time is also led in evidence in chief. It's a very precarious process because the cross-examination must be done up until the end.
I've done it a million times, fine.
As it is the court, madam.
And it's lawful, by the way. Continue with your cross-examination then. They say if you want to, you will recall this witness.
To me, it's really compartmentalizing the issue.
No, fine, but the general principle is, if a witness proffers an answer to evidence which he hasn't led in chief, but which he has subsequently deposed to in an affidavit, he can refer to it. You can't stop him and say, you didn't say that in chief. Please, I'm making that ruling.
Yes.
Right, let's continue then.
Yes, just maybe one point. The fact of the matter is the defense criticized the witness for not having shown communication between the accused. Now, he has done that, and I think, to me, the practical solution would be for him to then place that information on record, to say, listen, we have since gone and compile that information that the defense has requested, and then everybody gets the opportunity to cross-examine. That will, in my view, be a practical solution.
Mr. Gomezulu, I see you're shaking your head.
My Lord, I would actually make a submission to concur with Advocate Mnisi, in the sense that basically, and what is a principle of law relating to these procedures, it relates to prejudice. My submission is that I concur with Advocate Mnisi. Let the cross-examination proceed as it has carried on, because that's when, if the state brings the application now to listen to the new evidence, that's when the defense will determine whether there's prejudice against the accused.
I've also heard, Mr. Mnisi. Have you ever in your career heard of a court recalling a witness? Have you ever heard this?
Yes.
Not even consulting the defense.
The court, yes.
Yeah, it's section what? 167.
It's 167.
Then the court can re-examine that witness on the evidence he has said. In other words, I can say, are you aware that in terms of the principles of analyzing cell phone information, you can do A, B, C, and D. I can do that. And it's not me. It's this book. Let's read it. The court may, at any stage of criminal proceedings, at any stage, the court, examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance of such proceedings, and may recall and re-examine and at the proceedings, and the court may examine or record and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. That's what it says, not me. But we'll do it the way you suggest.
Correct, my
And
lord.
then me, after that, I'll do it in terms of section 167.
Court
Okay,
pleases.
continue, Mr. Nisi. Is nog onder het, meneer House? Okay.
Should I continue, madam?
Yes, yes.
Oh, thank you. Because I heard the court saying...
No, we
saying-
continue the way you say we must continue. You and Mr. Mnisi, and Mr. Shololo and Mr. Gomezu.
I basically was saying, I heard the court saying, saw him in.
No, I just said you are still under oath.
Oh,
It's not
okay,
under
no.
it.
No, thank you, madam.
Family, there we are. You know, much as this is not funny anymore to the Meyiwa family who are desperately waiting to hear where this court is going, where this case is going. I know Senzo Meyiwa's mom is desperately waiting for the verdict. He wants to know who killed his son. Much as it is like that, but ordinary South Africans like ourselves, we feel that we are learning a lot from this court. We're learning a lot from these arguments. Those who are into law, I'm sure they are learning. They will be able to correct some of the things that are happening here and ensure that in their offices, when they are there performing their duties as lawyers and all that, they are not doing the same mistakes. Family, thank you very much for watching this video to the end. Please like it before you leave. Subscribe for my channel if you haven't done so yet. I love you, family. Thank you. Bye.